So, okay, so what we'll do next week, everyone, is we'll take some time next week to go over the since it's the first unit discussion that we're going to have due in the class. What we'll do is uh, we'll go over it. We'll go over the actual discussion prompt. We'll talk about what the question is, what it's asking, what I'm looking for in that question. I'm going to give you all some suggestions, some hints, some tips in terms of how to go about answering the question. And then, of course, I'll also go over the rubric in terms of the requirements because, there are the discussion board like requirements like word length, sentence length requirements. I'll also give you all some suggestions in terms of how to do the responses because remember, you have to do 2 responses to classmates on top of the answering of the discussion. So I'll give you all like some hints and some suggestions in terms of like if I was in you all's position, like how would I answer these, and also to explain to you all like how I would go and do this. So we'll do that next week when we get to chapter 5, because the first unit, of course, is chapters 1 through 5 here. So with that being said, everyone, does anyone else have any other questions or comments or anything else like that that I can help y'all with? Everything else is okay with y'all? Everything else is okay? No other issues? Okay, no other issues? Okay, all right, then let's go ahead and get started here with chapter 4 here. So have y'all had a chance to, and I always ask this question, right? Have y'all had a chance to kind of go through chapter 4 a little bit or somewhat, not really? Y'all had to like kind of look through it or not so much, or could anyone kind of like, okay, so Hazel says not yet. Okay, so let's see. I'm waiting for it to share here. Okay, okay, good. There's the screen. Okay, so let me go ahead and go over here. All right, okay. So we're going to start with chapter 4 here, which deals with civil liberties. So civil liberties, as I think I said to you all last week, is definitely one of my favorite chapters because I have a criminal justice law enforcement background. I've got a master's in criminal justice. I've taught criminal justice. I've also, I've done a little bit of criminal justice work. Never a police officer, but I used to be a correctional officer and I used to be a security supervisor. So the reason why I mentioned that is because we're going to talk about, what civil liberties are and how they apply to, to everyday life within, people within America, right? And how civil liberties in America operate. So the reason why I mentioned about criminal justice is because we're going to take a look at the Bill of Rights. I think some of y'all have probably heard of the Bill of Rights before, right? Does anyone kind of remember like what are some examples of the Bill of Rights? Let's see. Did somebody type something in the chat here? Let's see. Okay, all right. So let's talk about that. So have you all heard of the Bill of Rights before? Is this something that you all have kind of familiar with, or maybe you've kind of heard of it? Are you all familiar with the Bill of Rights or not really? Are you all kind of heard of it, or? Okay, Hazel, you've heard of it. Okay, good. So how would you describe the Bill of Rights? Like, what do you think? Like, what are some examples of the Bill of Rights, and what do you think what do you think the Bill of Rights means to you? Like, what do you think of when you think of the Bill of Rights? Like, what are some like examples? What are some of those freedoms that you've probably heard of? Like when we're talking about the basic rights like freedom of speech. Okay, very good, Hazel. Yes, exactly. Freedom of speech. That's always the first one that everyone always seems to mention, right? The freedom of speech, right? And so we'll talk about freedom of speech because there are a few misnomers about freedom of speech. Um, we'll talk about what freedom of speech is. We're also going to talk about some of these other freedoms like freedom of the press, freedom of religion. I was starting my introduction, to talk a little bit about some of my criminal justice experience because a lot of the Bill of Rights deals with criminal law, criminal procedure, and what happens when you are suspected of committing a criminal offense, right? So we'll take a look at the Fourth Amendment, which talks about unreasonable searches and seizures, right? What counts as a search? Are there limits to searches? Um, what is it that the police need in order to conduct a search? We're gonna talk a little bit about that. We'll also talk about some of these other, like the Fifth Amendment. The right against double jeopardy and against self-incrimination. That's why everyone always, you probably seen the phrase like everyone says like I plead the fifth, like in some of these movies, like I know like Chappelle Show they do. There's a skit where they talk about that and he makes fun of it. We'll take a look at the Sixth Amendment, of course, the right to counsel. This is that right to an attorney. some of this should sound familiar to you, all right? I mean, because if you're familiar with the Miranda rights, if are y'all familiar with the Miranda rights, you definitely have seen that like in some of these cop shows like Law and Order. You probably heard of it, right? You know, I don't know, you haven't heard of the Miranda rights. So does this sound familiar? The whole like you have the right to remain silent, everything you say can be used against you. You have the right to an attorney if you can't afford one. One will be provided to you. That doesn't sound familiar to you. You have okay, good. Yes, I know you've heard it before because they say it all the time in these cop dramas and these courtroom dramas, you know, things like that. Because everybody loves these, right? You know, that's kind of the craze, right? Like CSI and all these other shows like SVU and all that. You know, everybody always likes these shows. Which I like them too. I just don't have the time to watch them because there's so many episodes. Like there's so many of them, so I just don't have time to like really sit down and watch them all. But yes, right. You all are familiar with this, right? So we're going to talk about the Miranda rights, where they came from, what they mean. Why is it important to know those rights? Why is it important to know that you have a right to an attorney? Why is it important that you know that you have that right to remain silent? Let's kind of discuss this a little bit, because I mean we'll get into it here when we go through the chapter. But let me ask you all this last question before we get started here. Why do you think it is important? Why is it so important for people to know those rights? Why do you think it is important? Because it is important, right? But why is it important? Why is it important for people to know those rights? What do y'all why do y'all think that is? What's the purpose of people knowing those rights? Why are we even covering this in our class today? What do you all think the purpose is? Or should we not know our rights? Is it not important? Like, what do y'all think? What do you all think about this? Because what could be a problem if you don't know your rights? What would be a problem? What do y'all think? Or or is there a problem without knowing your rights? What do y'all think? Imagine if like you were arrested and you didn't know that you could have an attorney. Hazel says, so we don't get taken advantage of, you could get in trouble. Right. Yes, you all are exactly right. They could incriminate themselves. Exactly. Right. Right. The thing about our rights is that we need to know those rights, and we need to know these rights because, like you all are saying, right? It could be something that could cause us more trouble, right? Um, it's important to know your rights because if the government is going to make this argument that you have committed an offense, then the government has to do their due diligence to prove that you've done this, right? The government can't just be going over there arresting people and just, you know, locking them up in jail and throwing away the key, right? We have to have what's called due process. We have to have a system in place where we have our day in court, where we can defend ourselves against these accusations, where the government has to prove beyond a reasonable doubt that we did commit this, right? Because when you get arrested, you're under control of the government, right? Your rights are restricted. You can't go home. You can't do whatever you want, right? You're going to be under control of the government. So because you're going to be under control of the government, then the government has to make sure that you did do this, right? And you also have to know the procedure. So if you get arrested, you also have to know what your next step is, right? You have to know that you can request an attorney. You have to know that you don't have to say anything to the investigators when they try to question you, right? You know, or you can say, you know, I'm not going to say anything until I have my attorney present, right? Because my attorney is going to counsel me on what I should say or not say, or whether I should say it, you know, because we're going to develop my case, right? So there's all these factors that go into this, right? Where you should definitely know what the procedure is so that you can properly defend yourself against these accusations, right? So all of this goes into this idea of, you know, the rights that we have. And so um, so even though, you know, the confusing thing about this idea of civil liberties is that people like they use the term interchangeably between civil rights and civil liberties. You know, they call civil liberties rights as well, so it can be confusing. Although we will talk about, you know, the differences here, especially when we get to the civil rights chapter next year, right? So, but let's take a look at the textbook definition of what civil liberties here, right? So, um, civil liberties, of course, are protections from government power and are different from civil rights. You know, the evolution of civil liberties comes mainly through judicial action, right? Um, so in terms of what civil liberties are, as it's defined here, it mentions that civil liberties are, these are the rights that we have, the protections that we have against government overreach, right? Where the government has limits on what they can do to us, right? The power that the government has over us. There are limits to that power, right? We do have protections against too much government interference in our daily lives, right? This is what civil liberties is all about, right? And so most of the civil liberties that we've gotten have come through judicial action. This is why in this chapter, there's going to be a bunch of Supreme Court cases we're going to be looking at. If you thought there was a lot of Supreme Court cases in the last chapter, oh, no, no. There's a bunch of them here in this chapter, as well as chapter 5. There's also, we'll take a look at several Supreme Court cases. So the next 2 chapters is going to be chock full of Supreme Court cases. And also do keep in mind, like we talked about in chapter 2, remember the importance of the Supreme Court cases, right? Remember the importance of understanding why do we pay attention when the Supreme Court makes a decision. Going back to what we talked about in chapter 2. Remember that when the Supreme Court makes a decision, that becomes case law, right? That becomes the law of the land. So that's why we're going to look at all these different Supreme Court cases, because they carry the rule, the weight of they carry the weight of law here, right? Through judicial action. And that's why there's so many of them, right? Because we're going to take a look at Miranda v. Arizona and what that and the impact that had on the Bill of Rights. We're going to take a look at Gideon versus Wainwright when it comes to this idea to the right to an attorney. There's all kinds of other cases we're going to take a look at here as well. Some a little bit less known than others. A fundamental clash exists between 2 forces: the basic duty of government and individual freedom. And boy, did we see this during the pandemic. Basic duties of government include protection of public health, safety, and the general welfare from danger such as crime or terrorism. Citizens' desire to go about their business without government interference, right? So these 2 sometimes they clash with each other, right? We saw it with the pandemic, although we've also seen it in other instances too, like at the turn of the 21st century, when we had 9/11. We also had a situation where you had a government that whose desire was to protect their citizens because of what happened on 9/11, and to go after terrorism, right? The whole war on terror during the Bush administration. And of course that led us to the enactment of the Patriot Act, right? But of course you also have to remember that the Patriot Act also had a lot of criticisms, right? Did the government go too far when it came to the wiretapping and the surveillance and monitoring certain websites and even monitoring libraries in terms of the types of books that were being checked out, and collecting all of this data and this information, even though people weren't necessarily violating any laws, right? The government has to walk that fine line, right? When we look at the pandemic, right, to public health, to ensure that try to not let as many people not try to do something about the COVID virus, right? Try to keep people from dying, right? But at the same time, that was also there was also a lot of criticism about the job that the government was doing, right, in terms of the mandates and the shutdowns and all that stuff, right? It's because again, in some cases, you do have a situation where they're going to clash, right? Because ideally, the government is supposed to let us go about our business. The government is supposed to let us go about our business as long as we're not violating any laws, right? It's not the government's business what I'm doing in my home. As long as it's legal, it's nobody's business, right? It's not the government's business. The police are not allowed to ring my doorbell and just stop by and say, hey, we're going to do a spot check here, just make sure you don't got any drugs or anything like that. We don't have a search warrant or anything like that. We don't have any suspicion that you're doing anything, but we're just checking all the houses just to make sure that you don't have anything. That's not allowed, because there's no reason for the government to to step into my house, because I haven't given the government any reason for them to do that, right? There's nothing that I'm doing that gives the government that suspicion to do so, right? Remember my story last week about what happened to me with the border patrol, right? I mean, just because I was driving late at night didn't mean that I was doing anything wrong. That's not a good enough reason to stop somebody. But again, like I said, I'm not going to debate the Fourth Amendment in the middle of nowhere, late at night. But again, do you all get what we're saying here, right? That the government has to walk that fine line, right? Where the government's not going to interfere in our personal lives as much as possible, unless there are like emergencies, right? Like public health emergencies, right? And things like that. But even then, there's still criticisms and disagreements about how these actions can happen, right? Um, so let's talk a little bit about some of the brief history of civil liberties, and then we'll get into the beginning of the Bill of Rights here. So the Constitutional Convention concluded without a Bill of Rights. The Federalists, led by Alexander Hamilton, argued that a Bill of Rights was unnecessary. According to Hamilton, a Bill of Rights would be irrelevant to a national government that was given only delegated powers in the first place. So what Hamilton is saying here is that, so you have to remember that the Anti-Federalists, this was the group of people that were pushing for a Bill of Rights. The Anti-Federalists, of course, they of course were very much concerned about a strong national government, having too much power over the people, right? I mean, this of course was, the main concern that the Anti-Federalists had in the first place, right? That's why we had the Articles of Confederation and how weak it was to begin with. So with this notion of increasing the power of the federal government to where the states and the federal government could kind of meet in the middle here, to kind of balance each other out. One of the provisions that the Anti-Federalists were wanting and what they were pushing for was for this inclusion of a Bill of Rights, more protections against the government. But again, Hamilton felt that this was irrelevant because he was saying that the national government is limited already in the powers that they have, right? That the national government does not have these powers that the Anti-Federalists are so concerned about, right? So Hamilton also argued for that the Constitution, as originally written, amounted to a Bill of Rights by including rights such as habeas corpus. So Hamilton was also making the argument that there's already these rights that the Anti-Federalists are wanting in a separate Bill of Rights. A lot of this is already in there. Habeas corpus is one of these examples, right? Habeas corpus refers to the right of an individual in custody to be brought before a judge for an open trial. So we will talk more about habeas corpus throughout this chapter, but basically what it basically amounts to the idea of due process, the idea that the process is going to be fair, that there is a process, right? This goes back to what I just mentioned right now, right? That if you are going to be accused of a crime, you're not just going to be hauled off to prison and then never be heard from again, right? You have the right to have a trial. You have the right to go before a judge and to have the government make this argument against you. You have these protections, right? So Hamilton was saying that the Anti-Federalist fears were unfounded because there's already protections in there, right? And these are some more of these examples, right? So these are not in the Bill of Rights. These are in the original Constitution, right? The guarantee of habeas corpus, this idea of due process. Whenever you're brought before a judge, right? That you have that right to be brought before a judge, and also the right to defend yourself in court, right? We've got other examples, right? Like the ex post facto laws, right? Where you can't be arrested for something that you did when, like let's say a new law is passed where something is illegal, but you did that same thing a year before that law was passed. Well, you can't be arrested for that because when you did it, it was legal, right? So these, some of these, examples here, some of these other ones, again, guarantee of trial by jury in state where crime was committed. So you can see that a lot of this is very familiar, right? And so Hamilton was making the argument that a lot of the provisions that the Anti-Federalists were wanting, it's already in the Constitution. So that's why he was saying that there was not a need for it. So, however, though, the Anti-Federalists still were making this argument, and they still argued that the lack of a Bill of Rights was a major imperfection. And so the Federalists ultimately agreed to add a Bill of Rights to address the concerns of the Anti-Federalists. The U.S. House adopted 17 amendments, and the Senate adopted 12. And so from the original 17, it got whittled down to 12. Then it finally got down to 10, which were ultimately ratified by the states. Now, what you also have to remember, everyone, here is that when people talk about the amendment of the Constitution, they talk about how the Constitution has been amended 27 times. It's been amended 27 times, right? But a lot of people don't count the 10 Bill of Rights as part of those 27 amendments, at least in terms of if we're looking at how many amendments we've seen since the Constitution was ratified, because the Bill of Rights were kind of tacked on through the ratification process, right? So that's why when people say, oh, the Constitution's been amended 17 times since the last 250 years, because they don't count the Bill of Rights in terms of actually truly amending the Constitution. But again, there's different opinions about that. But that's why people talk about that, right? Because it was pretty much within the same ratification process for the most part. So these 10 amendments, of course, called the Bill of Rights, and these rights represent important civil liberties, personal freedoms that are constitutionally protected from government interference. So, like we were talking about earlier, right? That The civil liberties are expectations that the government is not going to try to infringe upon these freedoms that we have, right? That we have that right to freedom of speech, where the government is not going to try to censor us, not try to, uh, not try to intimidate us if we speak out against the government or we criticize the government. The idea of freedom of religion, where religion is a personal matter and the government is not going to be favoring one religion over another, so to speak. The idea of a freedom of the press, where the press is independent of the government so that the press can provide an extra check on the government. And there's all kinds of these different rights. We'll also talk about the right to peacefully assemble, right? To be able to protest our government, to redress grievances, to contact our government to let them know how we feel about the job that they're doing. We'll talk about the Second Amendment, the right to bear arms, and we'll talk about the recent interpretation by the Supreme Court about what that means for firearms as to be able to carry them legally, for personal protection. We'll also talk about the Fourth Amendment against the reasonable searches and seizures and why the police have to engage in certain actions, right? It does talk about it here, next, right? So we kind of mentioned that a little bit, right? So when we look at the First Amendment, right? Congress, cannot make any law establishing a religion or abridging freedoms of religious exercise, speech, the press, assembly, or petition, right? As we just mentioned, right? That we have the ability to gather together and to petition our government, right? To contact our government, right? We have those rights, and to not, like I said, not to be censored by the government. And so then the next amendment's over here. No branch of government may infringe upon the right of the people to keep arms. That's the Second Amendment, which we definitely will have a good discussion about that. Because as I'm sure you all know, the Second Amendment is definitely one of the more controversial amendments of the Bill of Rights. There's a lot of different interpretations of it, and we'll look at those different interpretations here when we talk about it. They cannot arbitrarily take houses for the militia, so we'll talk about the quartering of the soldiers. What I like to mention, I've mentioned this before, right? That when you look at the Bill of Rights and you look at that, the Third Amendment is probably the most specific of them because it deals with one specific action. Because when you look at freedom of speech, that could mean a lot of things, but this third one right here, where basically that the military cannot force themselves into our house against our consent. That's a very specific thing, right? That's not, there's no room for interpretation there, right? It's extremely specific. It's clear as day. And what that says to me is that shows just how much the colonists must have hated that. They must have hated that so much that they put a specific amendment specifically for that specific event, that specific incident. So that's kind of what I look at when I read the Third Amendment. It's like, wow, like they must have really hated that to actually have one specific amendment dealing with one specific action. And then the Fourth Amendment, of course, cannot search for or seize evidence without a court warrant swearing to the probable existence of a crime, right? So we will talk about, and this should sound familiar, right? Because like I said, if you all have watched a lot of these, cop shows, you're probably familiar with the phrase probable cause, and that you need a search warrant in order to search someone's house. The search warrant has to be specific. Although we will talk about some exceptions to that, like we'll talk about the plain view doctrine and things like that. That's why I'm very thankful that I took a lot of criminal justice classes, because it builds on my ability to teach civil liberties here in government. So the courts, so let's kind of move on, right? And we're going to go more into detail on these throughout the chapter, right? So the courts cannot hold trials for serious offenses without provision for a grand jury. We'll talk about what a grand jury is. It's different from a trial jury. The trial jury, of course, also the grand jury happens at the beginning of the. Think of it as, and again, we'll go more into detail on it later on, but think of the grand jury as like at the beginning of the process, and the trial jury is at the end, right? A speedy trial. What does a speedy trial mean? That the government has to try to, finish. They have to try to give you a result of your case and your situation. This means that this means that you're not going to be arrested and then you're going to have to wait 10 years to actually get sentenced, right? The court has to get to your case as quickly as they can. This doesn't mean that you're going to get a result like the next day, right? Because obviously, of course, there's a lot of cases, but the court has to show that they're doing their best, right? To try to get to your case as quick as possible, right? Because you need a resolution, right? You need to know whether you're going to go to prison or you're going to be free, right? You need to know what's going to happen with your life. Presentation of charges, confrontation by the accused of hostile witness. So that leads into the whole idea of like cross-examination, where If someone takes the stand, they're also subjected to they're subjected to questions not just by the prosecution, but also by the defense, and vice versa, depending on which side they're on. Immunity from testimony against oneself. This is, of course, again, the self-incrimination, as well as immunity from trial more than once for the same offense. This is the double jeopardy provision, where so the immunity from testimony, right? This is where, again, you cannot be compelled to testify against yourself, right? That where if you feel that what you say would incriminate yourself, you can say, I'm gonna plead the fifth on this, right? I'm gonna take the Fifth Amendment, and I'm not going to answer this question or take the stand, because you have the right against incriminating yourself, right? As well as not being tried for the same offense, right? So if you're found to be not guilty, they can't come back and try you again just because the prosecution doesn't agree with the result, right? There's also neither bail nor punishment can be excessive. So this talks about the whole notion of that the punishment has to fit the crime when it comes to bail, where if you steal like a candy bar from HEB, they're not going to like put like $1 million bond on you because the offense is not a major one, right? So the bail has to be, the punishment has to fit the crime, and no property can be taken without just compensation. This is the eminent domain provision, where the government can take your property, but they have to pay you, they have to provide you just compensation. Now, of course, there's different interpretation of what just compensation means, but that's basically what it means. Any rights not enumerated. And then the last one, of course, we've talked about the reserve powers. Remember, we talked about this in chapter 3. Any rights? I'm sorry. The next one is that one, right? So the ninth one is any rights not enumerated are reserved to the states or the people. That's the 10th Amendment, right? And then the enumeration of certain rights in the Constitution should not be interpreted to mean those are the only rights that people have. So the Ninth Amendment talks about how that there could be other rights that the government is not aware of, but as those rights are discovered and applied to the Constitution, they can be applied, right? So I think that's pretty smart, right? That whatever else might exist later on in 200 years, that where people might have different rights that we hadn't thought of, that can also be included here. So again, we will go over all of this in more detail throughout the rest of the chapter here. So okay, so let's talk about a little bit more of the history here, right? So nationalizing the bill, right? Let me just make sure to see where we're at here. Okay, so I guess we will get to start with freedom of religion here before we enter today. So, okay. Okay, hold on, everyone. Give me just a minute. Let me just get a little bit of water here. I'll be right back. Give me just a moment here. Okay, everybody, sorry about that. I just was feeling a little bit lightheaded, just a bit. As I've told you before, I've been kind of dealing with a little bit of health issues recently, so but I'm okay. I just need to kind of pace myself a little bit here. Okay, all right. So let's go ahead and continue here. All right. So so what we're also going to take a look at here, everyone, is that one of the interesting interpretations of the Bill of Rights here is that originally, and let me kind of explain what this is talking about here, is that in 1833, in a case called Barron versus Baltimore, it doesn't say it here, but that's the name of the case. The Supreme Court ruled that the Bill of Rights limited only the actions of the federal government and not the state government. So this is an interesting situation where in 1833, the Supreme Court interpretation was that these Bill of Rights that we just mentioned here, that this only applied to the national government, where the national government could not establish, like an official religion or favor one religion over another, could not censor speech or things like that. The federal government was the only level of government that was restricted from this, but the states were not. So basically what this means here is that the states didn't have to abide by this. So the states could create official religions, like in Texas or any other states, right? The states could censor newspapers and things like that. So it's kind of interesting to think about, right? That you might think to yourself, well, does that really make sense, right? What you also have to remember, everyone, is that the national government is very small at this point, right? So the people aren't really going to be dealing with the national government for anything anyway, right? So the level of government that they're going to be having a lot more interaction with is the state. So you could make an argument that up until the Civil War that the Bill of Rights really wasn't being enforced at all, really, right? Because again, the states were the ones who were the heavy lifters when it came to government operations, right? So this is kind of an interesting situation, right, where we got the Bill of Rights, but they don't apply to the states, right? So of course this would change with the 14th Amendment after the Civil War, right, with the selective incorporation, which we'll talk about that here in a bit, right? So the 14th Amendment attempted to extend the Bill of Rights to the states. However, the Supreme Court did not apply this interpretation for nearly 100 years. So what we mean by this here is that instead of the Supreme Court just saying, okay, you know what, we're going to automatically apply it to the states. Instead, the Bill of Rights would be applied to the states through Supreme Court cases on a case-by-case basis, right? So that's why there's a lot of these different cases that we have here, right? So in 1897, the Supreme Court ruled that the Due Process Clause of the 14th Amendment did apply to the states. It prohibited the states from taking property for public use without just compensation. So this is the eminent domain situation, right? So now we have a Supreme Court case which now applies, the eminent domain circumstance, right? Then freedom of speech is now applied in 1925, right? Where the Supreme Court ruled the freedom of speech applied to the states, and freedom of speech is among the fundamental personal rights and liberties protected by the Due Process Clause, right? And you're going to see how there's a lot of these different cases. And again, you don't have to memorize all of these cases, but just be aware that this is how we have the rights that we have today under the Bill of Rights through these cases, right? And so the Supreme Court further expanded fundamental personal rights and liberties to include freedom of the press and freedom of assembly, right? So of course you also have to remember this is during the 1930s. Of course, this is during we start to see the Supreme Court start to be a little bit more activist under the FDR administration. So freedom of the press is added to the fundamental list. So is freedom of assembly in 1939 here. We also have the Palco v. Connecticut case. This is talking about selective incorporation here, right? The court did place some limits on the expansion of civil liberties under the 14th Amendment. The Palco v. Connecticut case, the court ruled that double jeopardy was not a provision of the Bill of Rights incorporated into the 14th Amendment. Established the principle of selective incorporation. Provisions of the Bill of Rights could be selectively applied as limits on the states through the 14th Amendment here, right? So what I want y'all to get from this, I know this is a little bit confusing, but what I want y'all to get here is that there's a reason why there's so many of these Supreme Court cases that deal with the Bill of Rights, because the idea is that the Bill of Rights would be applied to the states selectively, right? Where the Supreme Court would take a case and they would look at the circumstances of the case, and then they would then apply. They would then decide whether the Bill of Rights could be applied, in this situation or not, right? And there's cases even today that still deal with the civil liberties issues, right? Like I know, like every year there's always like a case coming out, like when it comes to like what counts as a search, especially. And the reason why this is important is because you have to remember that when the Constitution was founded, the framers had no idea that we would have like little mini computers in our hands, right? Like these cell phones, right? These smartphones that we have, right? And how they're basically like little mini computers, right? And they can house all this information. That was something that was beyond their scope of understanding, right? But that doesn't mean that the Constitution still doesn't apply to those types of new technologies and circumstances, right? Does unlocking a locked phone to try to get contacts, for a drug dealer, does that count as a search? That the founders would, if we get past, the whole notion of not understanding what a cell phone is, the courts, what they have to do is they have to apply, the founders' original intent behind the Bill of Rights and apply it to modern day, which again, that's a job for the courts to do, right? That's why we have courts, right? When things aren't clear, we have the courts and their interpretations, and they come in and they ultimately decide. So that's why there's going to be a lot of these cases that deal with a lot of these circumstances, like, the California v. Riley case, which talked about that situation that I just talked about, right? Does that count as a search? So we'll talk about that as we go through here. But I want you all to understand what selective incorporation means, right? And it gives the courts a little bit more leeway to be able to, to interpret the Bill of Rights here on the case by case basis, right? So it took more than 30 years for the court to nationalize a constitutional protection against double jeopardy, right? So, because originally they ruled that it wasn't, but then they reversed it later on. So until 1961, only the First Amendment and one clause of the Fifth Amendment had been incorporated into the 14th Amendment, right? So after 1961, most of the important provisions of the Bill of Rights were ultimately incorporated into the 14th Amendment and applied to the states, and only the Third and the Seventh Amendments remain incorporated. And the reason why the Third Amendment remains unincorporated is because, like I mentioned earlier, it's pretty clear that what it means, right? So no one has ever tried to act. The military has never tried to do it because it would be clear as day that they would not be allowed to do it, right? So that's why for the Third Amendment, it's very clear. That's why it hasn't been incorporated here yet. So okay, so that's kind of in a nutshell in terms of like the incorporation process here. I know it's a little bit convoluted, but just understand what we talked about, right? The idea that that's why we have so many of these Supreme Court cases, right? Because they have to be incorporated on this case by case basis here, right? So, okay, all right. So let's kind of move on here really quickly, and let's get to freedom of religion here. And then I don't know if we'll have time to get to freedom of speech. I don't think no, I don't think we will. I don't even know if we'll get to finish freedom of religion, but we'll start on it for sure. Okay, all right. So let's talk about this here really quickly. Okay, so let's talk about freedom of religion, right? So, um, so when we talk about freedom of religion is comprised of two specific clauses here, right? So it reads as it reads in the Constitution: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, right? So this is known as the Establishment Clause, right? The freedom from the state imposing any particular religion, right? So what the Establishment Clause means is that the United States is not going to create an official religion that everyone has to follow. Now, other countries don't have freedom of religion, right? If you go to some of these Middle Eastern countries where they, they practice what's called Sharia law, where the laws that are passed by those countries are based on the religious texts that they have, such as the Quran over there in the Middle East, where they craft their laws based on those religious documents, right? So there they don't have freedom of religion because religion is embedded within their government. Here, though, we're not supposed to do that. This goes back, of course, to the traditions of the founders. A lot of the founders were, they were agnostic. They were spiritual, but they weren't like, because this was during the Enlightenment period. So they were heavily influenced by the British philosophers. John Locke, John Stuart Mill, Jeremy Bentham, also Baruch Spinoza, not British, but another one of these political philosophers here. So they were being influenced by by the ideas of the Enlightenment, right? To look at more of natural science, right? To look at instead of necessarily looking at religious explanations, looking for scientific explanations. As science started to gain more and more acceptance within the world, right? So there is that thing. That context is important because I want for you all to understand why the founders were not wanting to replicate what was going on in England, right? They were trying to get away from the Anglican Church. I mean, right? I mean, that's why a lot of the original the original colonists were coming over to America, right? To practice religion their own way, right? And that leads us to the free exercise clause, right? The freedom to practice one's religion of choice without state interference. The free exercise clause basically means that religion is supposed to be looked at as a personal matter, and it's not the government's business to be deciding what people do with their religion, right? Provided, of course, that you're not violating any laws or things like that, right? But the idea is that the way you practice religion is supposed to be between you and your faith, and it's not the government's business to be regulating that. I don't know if you all remember the play in high school, and then of course they made a movie on it. The Crucible. I think some of you all are familiar, right? I think you all had to read it in high school. I know I had to. It was very interesting. Uh, or maybe it was in middle school. I don't know, but I read it and it was really interesting. There's a part in that play where John Proctor, right? He's kind of the main protagonist, where he gets in trouble with the local authorities there in Massachusetts because he's not attending church. I don't know if you all kind of remember that, right? Where they're taking church attendance, they see that he's not in church, and so now they're going and trying to figure out why is he not going to church? Is he like a witch or something like that, or is he being influenced by witchcraft, right? This, of course, is before the United States formed, right? This was back when Massachusetts was a colony of Great Britain, so there is no freedom of religion at that time. But I want to give you all an example of how that would be, that would clearly be a violation of the free exercise clause, because it's not the government's business to be checking on us whether we want to go to church, right? Everyone, they handle it differently, right? Some people they're there every Sunday. Some people are only there like on special occasions, like Christmas or things like that. I mean, that's of course, for people who are ascribed to the Christian faith, right? But it doesn't matter. Any of these other faiths, can also have, they can also worship as they please. Now, what this also does is by creating having freedom of religion, because religion is looked at as a personal matter, this also allows for the United States to have a lot of diversity when it comes to different religions. So when it comes to religion, Christianity still tends to be the dominant religion. And of course, that's for historical reasons, right? Because if we look at, why is the majority of the people here, in the United States Christian? Of course, you have to look at it for historical reasons, right? Because you had the British, that were colonizing there in the Northeast, and they brought their faith, the Anglican faith, as well as the Puritans. And then, of course, you also had, the French in Louisiana and up in Quebec, they brought Roman Catholicism, and you had the Spanish in Florida, as well as the American Southwest, right? They brought their Roman Catholicism, right? Um, if we had had, if this area had been settled by the Chinese, you'd probably have, Taoism or is the Buddhism, right? That would be the dominant religion here, right? So the dominant religion here was based on historical events. But with that being said, we have seen more diversity when it comes to religion, right? Even down here in the valley, right? We've seen. I know I've seen there by STC. We have the mosque, right? We've also got a couple of synagogues in the McAllen area. Even in Harlingen, we have the Scientology church. I don't know if y'all have heard of Scientology. It's that new religion with like all the movie stars, like Tom Cruise, they're all into it. It's based off of Dianetics and L. Ron Hubbard, the science fiction writer. So he started a religion, things like that. So I've done a little bit of research on it. It's kind of interesting. But so even new religions can pop up, right? Because of this idea that religion is supposed to be looked at as a personal matter, right? So obviously, of course, this is an important provision, right? To where and this allows for more religious diversity. It also allows for people to not believe in a religion, right? The idea of atheism has also gotten more popular, right? Where we just decide that we don't want to believe in a religion, right? We have that right to do so under freedom of religion as well here. Now, with that being said, though, there are different interpretations of the Establishment Clause, right? You've probably heard of, the wall of separation of church and state, right? That's when we look at when we look at this, right? But we'll come back to this, right? Video. So one interpretation, of course, is that the Establishment Clause prevents the establishment of official church. This interpretation reflects the views of many of the First Amendment's authors, because, like I mentioned, a lot of them were, spiritualists, agnostics, not necessarily spiritual, but not downright like super religious, right? Another interpretation is that the government cannot favor one religion over another. The government is still allowed to provide funds to religious institutions, but cannot show favoritism, right? So there's different interpretations of what the Establishment Clause is supposed to mean, because some people would feel like as we're going to mention right here, right, that there should be that wall of separation that was coined by Thomas Jefferson, right? It is meant to emphasize that government was not to involve itself in religious matters, nor religion to involve itself in government matters, right? There is disagreement, however, over the height of the wall. Prayer in schools is one such area of contestation. So basically what all this means here, everyone, is that, excuse me, give me just a moment here. Let me take another sip of water, hold on. The the idea here, everyone, is that there's different interpretations of um, what freedom of religion is supposed to mean. Some people would want to have an interpretation where government doesn't get involved at all with religion. We can't have any partnerships. We can't have any agreements. We can't have any type of involvement. This is a purely secular system, right? Where that's where the wall of separation of church and state comes from, right? Where religion has no involvement at all within the government. That's one interpretation. Um, but the other interpretation, but another interpretation, like it says here, is that government can still religion and government can still coexist and they can have partnerships and they can work together, but you can't have a situation where government is showing favoritism over, one religion over another, right? Um, Now, we did have a situation where government was showing favoritism when it came to school prayer. That's another famous case called Engel v. Vital, 1962, where this was the Supreme Court case where you had Christian prayers in schools, where you had the prayers that were being led by the teachers and the principals and all that stuff, where you actually had, Christian prayer. Now, there's a problem with this, right? Does anyone see a problem with having a public school leading a Christian prayer? Let's kind of talk about this here. Let's kind of open it up for questions again. So, what do y'all think could be a problem with that? What would be a problem with having public schools where you have the teachers in a public school leading a Christian prayer? What would be a problem with this? Or is there not a problem? What do y'all think? Is that okay under freedom of religion, or it's not okay? What do y'all think? What do y'all think? Before we, not everybody in that school is Christian. Yes, Hazel, you're exactly right. Because yes, how would non-Christian students feel about having to say a Christian prayer? It probably would make them feel uncomfortable, right? Because that's not their faith. So yes, you're exactly right. So in the Engel v. Vital case, the Supreme Court ruled that the schools themselves cannot lead Christian prayers, right? Because that creates a situation where you're favoring one religion over another, right? Now, that doesn't mean that you can't have prayer in schools. It's just that you have to do that on your own, right? Now, let me give you all another example here. Now, I think a lot of you all are familiar with the FCA, right? The Fellowship of Christian Athletes. I don't know if you all remember that organization, like when you all went to school. Now, though that organization is allowed to operate in a public school, right? Because they're there. You saw them, right? They had, they were advertising for it. So let's think about this a bit. It's a Christian organization operating in a public school. Why is that okay? Why is it okay for that organization to be there? Does that violate freedom of religion or not? What do y'all think? I mean, because obviously they were there, right? So obviously that would mean that it was okay for them to be there. So why do you think why is that okay? Why is having a Christian organization at school, why is that not a violation of freedom of religion? Let's see what y'all think. At that point, it's up to the students if they want to join. They're not being forced. Yes, Hazel, you're exactly right. Yes, that's the reason why it's okay. Because with the school prayers that were being led, that was forced, right? Where the students had to pray that, right? Because it was being led by the teachers, right? To start the day. For the FCA, it's optional, right? Students can join if they want to, right? It's not forced upon everyone, right? So yes, you're exactly right. That's why it is okay. Now, some people might still say, well, that's still, is that still favoring one religion over another, right? Well, that's another thing that I want y'all to understand, right? Is that there's different interpretations to this, right? It's not so clear in terms of, and that's why there's a lot of cases, especially that come out of Texas when it comes to like, the moment of silence, right? I think you all remember that also, right? If you remember, like from public schools where they had the moment of silence after they did the Pledge of Allegiance and the Texas Pledge, but that's another issue, right? Having the phrase "under God" in the pledge, and some people feel that that's also could be promoting one religion over another. But the Supreme Court has ruled that there's historical reasons for it. But even then, people have disagreements. So there's disagreements on this. Just because the Supreme Court rules something doesn't mean that people aren't going to disagree with it. Look at the Hobbs case that we just had for that overturned Roe versus Wade, right? So So yeah, there's plenty of people that disagree with Supreme Court cases all the time. But yeah, but the idea of prayer in school is that right, it can't be led by by the people at schools. But what about like at the football games, right, where you have like the players that will kneel, like because I was talking about this last week in my Texas government class, right? What about the football players that kneel like at the middle of the field and they're doing the prayer? Is that okay? They're wearing the school uniforms, right? They're at a school event. Is that considered okay? It's tough, right? It's kind of tough. You could see both arguments to this, right? So there is disagreement, right? I want you all to understand that it's not so clear cut, and there is disagreement on that. And again, and as well as the moment of silence, right? So the schools will give you some time to pray if you want to, but you don't have to, right? They're not making you pray, but they give you some time for people who want to pray through the moment of silence, so to speak. So okay, we'll pick up on this next time because it's already going to be time. We'll take a look at the Lemon versus Kurtzman case, and then we'll get to freedom of speech. So I don't know if we'll get to finish chapter 4, so we might need a little bit more time here. But again, if we need to push it back, that's fine. We've got time. But okay. So anybody have any other questions before we end for today? Anything else? Anything else before we end? I'm going to stop the recording.